where on the pleadings the court could just dismiss the complaint. The court could say, hey, we don't find that Multi-Financial is responsible for the acts of this particular individual as a matter of law, and the case would have been gone. Also, in federal court, judges who have very crowded calendars and under Civil Justice Expense and Delay Act, they sit on a motion for more than 90 days, their name goes on their door, and all their fellow judges learn about it, and their objective in life is to what? Clear their dockets. You know, clear the dockets. There's other cases that are out there. So the federal courts are going to get rid of those cases. They're going to dismiss those cases. Unless you've got a really good case, they're not going to tie up their courtroom for a 3-week jury trial if there's an ability to dismiss that case beforehand. And one of the most important things judges are going to enforce is the statute of limitations. So if you're a day late and $1 short, LAMP had no statute of repose. It was 1 year from the date of knowledge upon exercise of reasonable discovery, or never more than 3 years from the date of events. So if you were a day late and $1 short, a federal judge would not hesitate to dismiss your complaint based on the statute of limitations. Well, there's been a lot of discussion in a lot of the scholarly materials on whether or not the statute of limitations even apply to arbitrations. Because earlier we talked about how statutes of limitations are limitations for courts. The courts were created by the sovereign, and the sovereign was limiting the ability to use those courts to do your cause of action. So since arbitration is not a court proceeding, there is no statute of limitations. Instead, there's a thing called eligibility. That no more than 6 years from the date of events giving rise to the claim are only eligible. So the wrongful act occurs at the time, the defendants are going to say, occurs at the time the securities are sold. The event giving rise to Mrs. Brown's claim occurred when her broker sold her these unregistered securities. That was the event. So too bad she discovered her event, 3 years and 2 days later, because more than 3 years had elapsed since the event giving rise to the claim. Well, in arbitration, we can make an equitable tolling argument. We can make an argument, well, every time she spoke to her broker and he told her everything was going to be okay, or that these securities were good, or the company was in really wonderful shape, that's an ongoing course of fraudulent conduct. Those are separate events. It's another lie. When the client calls the broker and says, what's wrong with my account? And the broker says, everything's fine, just hang in there. Even though he may have sold her, or she may have sold him those securities 2 years before, that's an ongoing fraudulent event. It's an omission of material fact. The broker should probably tell the client, everything's okay, but I forgot to tell you, the securities we sold you are really risky. So when the broker chooses to speak and doesn't speak truthfully and tell the whole truth, but what's left out is an omission. We know from 10b-5, a misstatement or omission of material fact. And we'll talk more about this later when we talk about different causes of action and what omissions mean. But let's look at some of the restrictions on substantive rights. And I want to ask you folks whether or not you think these restrictions are merely procedural or are they really substantive. Some of the things that you're not allowed to do in arbitration that you would be able to do in court, which have been characterized as procedural limitations, but I think they're substantive because I think they affect the substance of the case. They go directly to the merits of the case and the ability to prove the merits. And the first one I want to talk about is discovery. Have you all seen the NASD Discovery Guide, Notice of Members 9990? Have you all read that? It's interesting because before the Discovery Guide came out, a lot of litigation, matter of fact, probably 80% of the work that was done in any of these cases was arguing over discovery. Respondents want people's college transcripts. They want loan applications. They want grade school transcripts if they can get them. They want the claimant's telephone records. They want the claimant's screen names because they want to go on the internet and see whether or not the claimant's ever posted anything on a website. They want a laundry list of things that generally the claimant's bar doesn't want to turn over. Conversely, us claimants, we want a lot of documents that the respondent's bar just doesn't want to turn over. We want actual disciplinary actions against the client, against the broker. We just don't want to see on a disclosure reporting page what general counsel says the substance of a complaint, a prior customer complaint against this broker is. We want to see the actual underlying customer complaint. You read the underlying customer complaint, my broker sold me these securities, I told him I was retired, the broker told me my mother owned these securities, they lost 80% of their value, the broker did all these horrible, horrible things. And then when you read the disclosure reporting page, it says, client complained she lost money. Well, that's the version that's digestible for regulators. That's the version that they